this case, Mr. Bradshaw, a wholesaler, placed 6 wooden barrels of orange juice with Spurlings, who were warehouse operators, until he was ready to take delivery. He had done business with Spurlings many times before. The contract for storage on each occasion had included a long and rather tortured exclusion clause, which I've cut down to read, "We will not, in any circumstances, be liable for any loss, damage, or detention, howsoever, whensoever, or wheresoever occasioned, even when such loss, damage, or detention may have been occasioned by the negligence, wrongful act, or default of ourselves, or our servants or agents, or others for whose acts we would otherwise be responsible." The exclusion clause was on the back of a document in relatively fine print, but there were more prominent statements saying goods held at own risk and notifying customers that goods were not insured unless instructions were given to insure the goods. So a reasonable business person should have been thinking carefully about the management of risk. When Bradshaw arranged to collect the barrels, he claimed that they had been negligently stored and their contents were ruined. The claim was a bit dubious because it wasn't made immediately. It was made after the warehouse had started pursuing him for unpaid bills. However, by the time the matter got to the Court of Appeal, some level of negligence was accepted. The dispute was now a question of whether the exclusion clause applied. Bradshaw claimed it did not because it was hidden away in the fine print. Lord Denning said, "I quite agree that the more unreasonable a clause is, the greater the notice which must be given of it. Some clauses which I have seen would need to be printed in red ink on the face of the document with a red hand pointing to it before the notice could be held to be sufficient." The clause in this case, however, in my judgment, does not call for such exceptional treatment, especially when it is construed as it should be, subject to the proviso that it only applies when the warehouseman is carrying out his contract, and not when he is deviating from it or breaking it in a radical respect. This case confirms then that the more sweeping an exclusion clause is, the more notice will need to be given in order to make it effective.